handout.
We'll get better at that as this session goes on.
I'm sure it was my fault, Chairman. Mr. Chairman, members of the committee, thank you so much. My name is Bryan Blevins on behalf of the Texas Trial Lawyers Association. We're testifying on the bill and want to express our appreciation to Chairman Smithy for his efforts in this regard and also for the opportunity to continue to work with him on the bill. But we do have some concerns. The FAIR Act is unique and it is different from TWIA, and that's where one of our concerns is extending these significant protections that were granted to TWIA to the FAIR Act, because the FAIR Act is fundamentally different. It's not geographically limited like TWIA. It's not a catastrophic program like TWIA. It is supposed to be a statewide program. But most importantly, it's a profit center for the insurance industry. Very different from TWIA is that the FAIR plan at the end of a particular year, if there are profits, those are actually earned by the association members, the insurance company. So for instance, in 2014, the FAIR plan actually generated $42.8 million in net profits. So as long as reserves are maintained, then those profits can be distributed to the members. And so in TWIA, the public policy decision was to reduce litigation, reduce costs, so that premiums could go down because payments were also going down, so premiums could go down. Here, a reduction in holding FAIR accountable would mean that costs go down, claims go down, but profits would go up, and not necessarily tied to premiums going down. The other issue that concerns us is relative to the funding mechanism, because actually there's never been a call in TWIA because of the catastrophic losses. There was concern that there was going to be a state liability at the end of that, and we needed to protect, at the end of the day, the state's assets. Here, that's never happened. In fact, there's never been a call, even on the assessments to the insurance industry. There's $40 million in reserves. There's $360 million in reinsurance. And then the next is an insurance member assessment, which has never happened, which is then subject to a surcharge to the clients. Ultimately, the states, there's no state liability relative to the FAIR plan. $75 million could be issued as public bonds, but under statute, state law 2211-208, that is not a debt of the state. So our concerns are that before we take away the rights and remedies of the policyholders under the FAIR plan, we ought to look at the need, the public policy issue. Are they the same as TWIA? And then the handout that I provided, which shows that there's a real focus of these claims for reasons unknown in Harris County. Almost 69% of all of the FAIR policies are sold in Harris County, even though this is a statewide program. It's a very unusual outcome. We don't know why. And before we take that next step, we would suggest that perhaps an interim in that area should be looked at, as well as the commission structure for how these policies are sold. But I'm happy to answer any questions.
Members, are there any questions for Mr. Blevins? Representative Garrett.
I assume you're working diligently with Chairman Smithy?
We will, and we are. We've been trying to get together. There's several large insurance bills that Chairman Smithy is working on, and we're trying to work with him, which again, changes, for instance, in the bill that we're going to talk about here later, changes in that bill would then impact potentially policy claims here as well, which again might alleviate whatever concerns there are with the FAIR plan. So we see them as interrelated, and we've absolutely made ourselves available and want to continue to work with the chairman.
I find Chairman Smith is a very honest man, so I'll be checking with him as we move along here as to where everybody is.
Yes, sir.
Thank you.
Members, any other questions? All right. Thank you for your testimony.